This is Things I Need to Learn in Life I Didn't Learn in School, covering everything we should know as adults that got glossed over in our classrooms. With your host, Wave News anchor, Dawne Gee.
We always welcome you to Things I Need to Learn in Life I Didn't Learn in School. Thank you for joining me, Dawne Gee. Today we are talking about a very difficult topic. It's a topic I feel like most Americans do not talk about, and that is being prepared when we leave this earth and everything that we need to do. Tom Stone joining me here. Tom, this is what you do for a living. You are a lawyer. You try to make sure that everybody has in place things that will make life easier for their loved ones that are left behind. Talk about what you do and the name of your legal firm.
First of all, thank you for having me on the podcast. What we do is we help people who value their legacy carry out their wishes through the tools of estate planning and probate. And by that, we say the probate is what is the plan that you want for, first of all, what happens to you, and what happens with your family. That can be your spouse, your children, grandchildren, brothers, sisters, whoever you choose to put into your estate plan and provide. Now, there are many ways that can happen. There are many types of documents that need to be in an estate plan, but your three basic ones, and when I say basic, I mean very, very basic. First of all would be a last will and testament. Second would be a durable power of attorney. And third would be a living will with a healthcare surrogate designation.
Why is it we feel like if somebody's not a millionaire or something like that, they feel, I don't need all that stuff?
Well, I think that's an old myth from way back probably 40, 50 years ago. At that point in time, most people didn't need to have any kind of a complicated or complex plan. Things were much simpler. But things have changed in the last 40 to 50 years, and nowadays there are reasons for the average person to have a trust as opposed to just a will. And the question I always get is, why? I am not wealthy. Why do I need it? I don't have millions of dollars. Well, that's true to a degree. Now, at the present time, if you have less than $12 million in personal assets, which is basically...
Okay, I don't have that.
Okay, yeah. You have lots of company. Basically, 99.5% of the American population does not need or have that type of wealth. However, by utilizing a well-prepared trust, you can take a lot of the stress off of your family or those people that are left behind when you pass away, and they have to deal with your estate. Now, typically, if you have a last will and testament, here's the process that you're going to go through. Number one, you're going to go see an attorney. The attorney's going to review the will, make sure certain things are in place.
Do they help you with that will? Now, I've done this, and let me just say this, and you all pretty much know my life. I ended up doing this because when I had a stroke, I can remember not being able to move, not being able to do much, and I began to see my family arguing about what medication do we give her? You know, what do we do if she goes in a coma? And my kids were arguing with each other. My mom had passed out, and I remember laughing in my head at that time, okay, if this is it for me, I did not plan well.
Well, your story is quite familiar to us. Let me kind of back up for just a moment here with the question you asked. 62 to 66% of the American population, and I'm talking about people over the age of 18 because that's when you become an adult, have absolutely no estate plan whatsoever. So all those documents that I just mentioned, they don't have any of them. So what happens in that...
Should they at that age?
Absolutely.
Okay.
Absolutely. Okay. And let me kind of say why. First of all, if you don't have any sort of an estate plan, the state has the default plan for you, and it's called intestate succession. And what they will do is they will say, okay, Dawne, you have passed away, so we're going to give everything that you have according to our plan, not anything you may have ever wanted.
And I'm not knocking the state, but very seldom do I want to defer my life and what I'm doing to the state.
Well, correct. And here's why people don't understand until it's too late that the default plan of intestate succession is not really what you want to have happen. First of all, when you pass away and the court starts to administer your estate, and if you have no plan whatsoever, they're going to give everything first to your children. So if you have a spouse, for example, that spouse does not automatically, just because you were married, inherit everything the two of you all have worked together.
Okay, you told me this the other day, and
I
almost fell out of my chair.
Right.
So if I'm, like my age, I'm almost 60 years old, and I was married, and I have my kids. When I die, this is what the state's going to do. It goes to your children.
Children first.
Which is not bad, because that's what's going to happen. My children will get everything. But that's a problem, because what if you're married and you want your wife to have it, and maybe your wife is not the mother of your children?
Correct.
And maybe those children are going, we're not giving her nothing. But that's what the state says. That's what's going to happen.
Right.
So it's children, then brothers and
parents.
Parents?
Your parents come next, then your brothers and
then
sisters
brothers
are third,
and sisters.
and then your spouse is fourth.
I never knew that.
Well, a lot of people just make those false assumptions because they think, well, we file our taxes together, we have maybe a checking account together, so that checking account that I have over here, that'll go to them too because we're married. No, absolutely not. Now, there are some statutes where you can declare for what's called the widow or widower's share, and you will get a portion.
But do you have to fight for that if it wasn't in a will?
I mean, if you don't do anything, if you don't come forward, then there's a possibility that those children that are not yours aren't going to admit that there is a spouse out there. Now, that would be misleading the court, and I certainly do not advocate ever doing anything like that. But we see a lot of people come in, and they don't tell us that there might be a spouse out there that's not their mother, and they try to pull the wool over your eyes from time to time.
And death occasionally will tear a family up.
Yes. And I'm sad to say that we have seen a number of families that split over because of how the estate came out, or they didn't get something that they really wanted, and it devolves down in just to an all-out fight. So it's much better coming back around to having something in writing about what you want to have happen. And as I started out, the three basic documents that can make sure that you're taken care of both now and when you pass away are those three documents.
Say them again, please.
And that is a last will and testament, a durable power of attorney, and a living will with a healthcare surrogate designation. Now, we advocate going one step further, and that is to utilize a trust. And the most common one that you're going to hear about is a revocable living trust. Why? Because if you do your revocable living trust correctly, you bypass probate. Now, how is that helpful?
Wait a minute. I hear probate all the time. What is probate?
Probate is the state process whereby you have a court determine, first of all, do you have a will? If so, can the court admit that will because it was written according to the statutory requirements? If the will is admitted, then the individual named in there will be appointed and given authority to act on behalf of the estate to wrap up your affairs. That's the person who's going to gather the assets, pay the bills, and distribute your estate according to what you say in that document. Now, what does that mean? Well, first you have to get on the court docket. That might take anywhere from 2 to 4 weeks. Thank goodness we are starting to see the time frame come down. But right after COVID, it was not uncommon to be 3 months to get a court date because there were so many cases here, and I'm speaking mainly of Jefferson County. Secondly, probate is a process that is controlled by the state. Even though you have a will that says, I want it all to go to A, B, and C, the state is going to be monitoring that. So every so often, there are timetables that have to be met. You have to file an inventory. If an inheritance tax return is due, that has certain due dates that they must be filed by. And then if you haven't finished the estate within 2 years, the state's going to want to know why. So all of this, the more time that it takes, obviously there is a cost when you have an attorney representing you. So
And do you have to have an attorney?
You do not have to have an attorney. However, the court is going to hold you, the citizen, to the same rules that we have to abide by. So that's those timetables that I was referring to. So if you miss the timetable, the court can remove you and appoint the public administrator instead of a relative who the deceased may have preferred to be the person in charge of their estate.
Okay, so we all know what a will and testament is. It just pretty much lays out what I have and who I want it to go to.
And who's going to be in charge.
Okay, and who's going to be in charge when I die?
That is correct.
The next one you said was?
The durable power of attorney.
Okay, durable power of attorney means what?
Durable power of attorney is your appointment of someone to act in your place when you are unable to do so. And that can be because, number one, you have become incompetent. You have a stroke. You've been involved in an automobile accident and you've suffered some kind of brain damage, which you may not be able to have the same comprehension. For example, a 55-year-old individual goes in, has an automobile accident, suffers traumatic brain injury, now has the comprehension of a 10 or 12-year-old. Well, they're not going to be able to transact complex business decisions anymore. So someone is going to have to step in.
And you need to have that done because you don't know when you're going to have a stroke. You don't know when you're going to have an accident.
That's correct. And quite honestly, I think that the durable power of attorney is probably the most important document for the individual while they're alive for that very reason. Because the alternative is, if you don't have a durable power of attorney, you have to go back to court. And you go to disability court, someone petitions on your behalf, the court appoints an attorney to defend you, which is called a guardian ad litem. You're examined by a panel of 3 professionals, a doctor, a psychologist, and a social worker. They all file their report to the court as to whether or not they believe, are you or are you not competent. Then you have a jury trial in front of a 6-person jury. They go back after hearing all the evidence, they vote. Do we believe that Tom is competent or incompetent? And the person who has applied to be the guardian is then appointed. Well, you don't have any say-so in this whole process, number one.
So you better pick someone you love and trust and who loves and trusts
absolutely,
you.
absolutely.
Better think about that.
You better think about it. Because the other side of this is that disability proceeding is all coming out of your pocket. This is not funded by the state.
So even though you're not even there for all practical purposes, you're still paying for it.
Correct. You're physically present unless it would be harmful to you is what the statute says.
Right.
But you're absolutely right. You really aren't there
at
that point. But you are paying thousands and thousands of dollars for this proceeding that you could have averted for a fraction of the cost.
Had you had that paperwork done.
Exactly.
Okay.
Exactly.
What was the last thing?
That's a living will with a healthcare surrogate designation.
That's kind of like the same thing, right? If I can't make my medical choices, someone does it for me?
It is an end-of-life advance directive is what it is. And while you are competent today, if we were signing one for you, for example, you are stating in writing, when I am in a irrevocable or terminal condition, that's number one. Number two, it is certified by 2 doctors. And essentially at that point, what they are saying is you are not going to live unless you're attached to machines to support you. And at that point, it's as if we could talk to you, what would you say? You would say, disconnect the machines, let me die naturally.
Well, I had a dear friend who worked here who was in an accident, and he was hooked up to machinery for quite some time, and his wife decided it was time to let him go, but his parents did not, and it became a huge legal battle. If I have that, is all of that taken care of?
For the most part, yes. That's going to go a long way to stopping the scenario that you just set forth. The most famous one that I refer to is Terri Schiavo, the individual in Florida. That unfortunate situation lasted for a long time. I think her first, when she had the episode of the stroke that she had, was I believe in like 1998. And it went all the way to like 2005 before they were able to get it all snapped up and resolved, and the court said, no, let her die.
My dad has said, don't hook me up, don't do this, don't, and I have said, hey, can I see your paperwork? Because I don't want my sister and I to be in a battle of, well, Dad said, don't hook him up. And somebody else in the family says, but we're hooking him up. I don't want to get in a battle. And my parents won't talk to me about that.
Well,
I think that everybody should make sure everybody knows where that paperwork is. Number one, have the paperwork. Make sure it's all legal, and make sure everybody understands.
Hospitals and physicians are very reluctant to unplug somebody if there's even just one family member that doesn't agree, because they're afraid, obviously, of lawsuits. Whereas if you have the document and it's written and you put it in, and one of the things that is the smart thing to do is once you execute that living will, the best advice is every time you go to the doctor, take a copy with you.
They always ask me when I'm admitted, do you have a living will?
That's right.
I do. Do we have it on file? No.
Well, you need, our instructions are that when you go to that next appointment, to whatever that doctor may be, wherever that facility may be, if you're going for, say, physical therapy, even lab work, take a copy with you, put it in your file. With the electronic records that they have nowadays, it's much easier to transfer between the various institutions than it was when it was all paper. Only.
Okay. What am I missing here? I guess the question is this expensive? I want to do it right. I want to keep my family from going through any other pains that they may be going through if I'm hurt or dead. But how much is this going to cost me?
Well, that's a very broad target for a couple of reasons. Number one, it depends on what you need in terms of an estate plan.
But we all need all of that, right?
Well,
maybe we don't all have a lot of money or property.
Well, it's not a lot of money that's the issue. The question is, how do you want to spend your money? And by that, let me kind of illustrate what I'm saying. When we were talking a little bit earlier, we were talking about going to probate court with a last will and testament. First, you pay for the will to be prepared. Then, at some point down the road, that is presented to the court. So you've got court filing fees, you've got attorney's fees that you're going to take on. In Jefferson County, we've kind of looked very broadly. The mean cost for a probate in Jefferson County, you're probably looking somewhere in the neighborhood of between $5,000 to $7,500.
Oh.
Now that's an average. Some can be way more, and when I say way more, I'm talking 5 figures and beyond to 2 as your first number, or more, depending. If everybody wants to fight for 10 years, it could be a horrendous bill. On the other hand, it may be a little bit less because things are very simple. But as a mean average, that's what we have seen over the years here. And of course, the cost of everything does creep up over time. So, our position is we think it's best that you not go to probate court, but use alternative methods for transferring your estate when you pass away. So I'm coming back to the revocable living trust that I mentioned earlier, because number one, you can accomplish the very same things that you do with a will, and that is to my spouse, to my children, my grandchildren, my brothers and sisters, whoever you want to provide for. You can still do that with the revocable living trust, but you don't go to probate court. So you're not stuck in that cycle of, and again, the average probate in Jefferson County is somewhere between 6 to 12 months before you reach the end of that cycle.
That's a long time to draw that out anyway, because you are already emotionally at your wits. And so I see all the time on TV or different places where it says, you can just come to this computer site. Yes? No?
No. 98% of the people should run away from an online, and here's why. The online really can't ask follow-up questions when somebody will say something. For example, we sit down, and how we work it is we will sit down and we just let you talk for a while. We want to know about your family. We want to know what bothers you. What's your biggest concerns? And in those conversations, things will come out. Well, the computer's not going to know those things because it'll say, do you want to leave it to your spouse? Yes, no. Insert spouse's name. Do you have children? Yes, no. Do you want anything to go to your children? Yes. When do you want your children to get it? If my spouse doesn't survive, click. Nowhere in there is it going to ask you, does one of your children have a substance abuse problem? Do one of your children or more have maybe some issues, mental health issues, that they can't handle their finances? So maybe they need a trust that is designed to address that specific issue. Those are the things that the computer can't ask you, but we can, or a good estate planner can add to those documents so that it is much more direct and set up just for what you and you alone need. Because this is not estate planning.
It's not a cookie cutter.
Yes. ABC
done.
Correct.
And I mean, everybody should think about this.
They should. They should. We unfortunately what we see coming through for probate does mirror that 62 to 66%. Of all the probates we do, about 65% are no will or anything, and they are always very surprised, as you were when we had our discussion the other day, that what? I'm not going to get it all?
Yeah, I mean, I thought it was immediately your wife and then maybe your child. I had no idea it was children, parents, siblings, then spouse.
Right.
That floored me.
Well, understand, that's Kentucky's plan. Kentucky...
And so every state could be different.
And
so
they are.
If I move...
It could be different.
Do I need to redo that, or...
Most of the time, the documents, if they're executed correctly in the state where they originate, they will be good elsewhere. So if you move from here to another state, those documents are portable and will be okay to use in a new residential estate.
All right. Well, like I said, when I had my stroke, I began to get my documents in order, and then not too far after, I had a pulmonary embolism, which was another life-threatening thing. Now, granted, I have the simplest of forms together, but I'm sure it's not exactly what it should be. I got this book. It's called Peace of Mind Planner. Now, I have junk all shoved in here, and I have not, it has in here personal, medical, key contacts, time of passing, my dependents, my important documents. I don't have nothing in here yet, okay, but I'm working on it. I even have poems that I want in my program, when I die and all of that. It's good, I think, to maybe put everything in somewhere like this and then let somebody know where it is.
Well, that's the two most important things that the individual, can do. First of all, make sure that your executor, your trustee, whichever plan you ultimately choose to go with, make sure they know where those original documents are. Don't just throw it in the drawer and assume that they'll ruffle through your house and find it. Put it someplace and tell those people, my executor, my trustee, my power of attorney, all of my documents are located wherever. Third drawer of my desk, or they're in the blue binder on my desk. But make sure they know where those are, because number one, that's going to save a whole lot of problem. If they can't find it, then everything you just put together...
It's for naught.
For naught.
Yeah. Why are we as Americans like that? They have occasionally what's called a death conference here, and it's literally everything about death. And when they called me and asked me if I wanted to participate, I was initially offended, like, how dare you talk to me? But why are we like that? Because if you go to other countries, they plan for it, they celebrate it, they talk to, but you talk to us and we don't want anything to do with it.
I think there's a couple of things that are at play there. One, just plain old procrastination. You talk to a 35 or a 45-year-old individual.
They think they're not going anywhere.
That's right. I've got plenty of time. My parents, grandparents, we come from a family where everybody lives to be, mid-90s and up. I've got a good 50 years before I need to worry about that. The other one is honest to goodness, there are people who really don't want to think about their own death. It's inevitable, and the old cliche, there's only two things in life you can count on, death and taxes. That's right. But that is a big block for a lot of people, is they just don't want to deal with it. And we try to help from an educational standpoint, educate them this is what's going to happen if you do nothing. And a lot of times that gets over that hump of putting it off. Then they understand what happens if I don't do anything, how my family's going to be thrown into chaos, how my spouse is not going to be able to have all of what we have accumulated. One of my favorite, and I say favorite not in a good way, but in a very illustrative way, we had one about 10 years ago, a probate, a young couple doing very nicely. He was a Navy individual, was on active duty at Pearl Harbor. Unfortunately, was involved in a motorcycle accident and died. Everything was in his sole name. The house, all the automobiles, all the bank accounts, everything was in his sole name. Mom and the children were here in Louisville, and the children were 7 and 4. So what ended up happening is, because he did not have a will, and as we talked about at the top of the podcast, the kids ended up inheriting. Now, she exercised her widower's statutory exemption. She was able to get half of the house, but we had to come up with a plan to buy out 25% from the 7-year-old, 25% of the 4-year-old of a $250,000 house. If he had had just a simple one-line will, even, all to my spouse, period, she would have gotten everything.
That's so crazy to me. Okay, we're about at the end of our time here, but first thing we need to do, like, do we have to start gathering all these records? I'm just like, I don't even know what I have. I mean, to be honest, I don't have a clue. I don't know how much anything is worth, and I just feel like it's going to be too overwhelming. What's the first step?
Well, we do not need to know what you own per se. We just need to know approximately. Do you have automobiles? Yeah. Do you have some real estate? Yeah. Do you have some investments? Yeah, there's somewhere, but I'm not real sure how much it's worth. That's okay. We don't need to know your exact values in order to put together the plan. The only time that becomes important is if you're going to have, as a single individual, each individual, has more than $12 million of assets.
Most of us don't have to worry.
Again, 99.5% don't. But if you did, then yes, we would need to know a little bit more about your assets, because we're going to have to approach that in a different way. Estate planning is very customized, or it should be. And if someone comes in or you're sitting there talking to someone about an estate plan, and all they want to know is, who you married to, you single, okay, who your children, don't have any children, who do you want your stuff to go to, and that's all they're going to ask you, then they're really not planning your estate. They're just giving you a fill-in-the-blank boilerplate document that probably isn't going to do what you really want it to do in the long run. And it's a very good possibility that when you need that document to perform for you, the person who drafted it and the witness can't be found, because they did not do what's called a self-proving document. And so then, if this document's 30 years old, that those two individuals could be gone, or they may have died already. So now we have to go through a whole nother rigmarole to try to get that will admitted.
Who am I going to see to make all of this happen correctly?
You want someone who practices in the estate planning area. You don't want to go to the person that closed your house. You don't want to go to the criminal lawyer that got you off of the bad check charge. You want to go to someone who does estate planning, because they're going to know to ask all these questions, number one. Number two, they're going to be looking for those things that you don't even realize are out there. And that comes back to what I was talking about, that listening at the very beginning. When you're in that appointment, and that individual, they should be listening to you first, not talking. And if they're listening, that's your first good sign that you may be on the right track. Secondly, if they ask you a lot of questions, that's another good sign. Third, if the door says estate planning, that's your key that you're in the right place.
All right. You are Tom Stone, the name of your firm?
Stone Legal Group, PLLC.
And you're easy to find.
We are at 9200 Shelbyville Road, Suite 600. If you know where the Flash Cube building is, that's not us. We're the dark building that's the twin.
Okay.
Next to behind PF Chang's.
All right. This is the most important thing you can do.
Yes, it is. It is extremely important, and it's really not that complicated.
And you don't wait until you're 80.
Correct, because that may be too late.
All right. I appreciate you.
Thank
Anything
you.
else you wanted to add?
I was going to say, when it comes to your estate plan, this is the key phrase you need to remember. You're never too young, you're never too old, but you can be too late.
Oh, you just gave me chills. There you go. Honestly, I know we don't like to think about it, but it's things I need to learn in life that I didn't learn in school. So it's something that you have to think about, something you have to learn, and then something you have to actively put in practice. Tom, thank you.
Thank you.
So very much. Thank you all always for joining me, and we'll have another topic next week. I'm Dawne Gee. Thank you for joining me.